Pledge of Allegiance, so all rise. Thank you.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The Land Use Board Open Public Meeting Act Statement of Adequate Notice. I hereby announce and state that adequate notice of this meeting was provided by the Secretary of the Rockaway Borough Land Use Board by preparing notice dated January 7, 2025, specifying the time, date, and place of this meeting, posting such notice on the bulletin board of Lowell Hall, filing said notice with the clerk of the county of Morris, and publishing the notice in the Daily Record newspaper. I hereby hand a copy of such notice to the Secretary of the Borough of Rockaway Land Use Board for inclusion in the minutes of this meeting. All the above being in accordance with NJSA 10, 4-6 et sequitur Open Public Meeting Act, and I am Ken Blair, the chairperson of the board. Please make note that there are fire exits if we have to get out of the building in a hurry, ahead of you and to your right or behind you to your left. And that the board has determined that no new cases will be heard after 9:30 and no testimony after 10 p.m. And may we please have a roll call?
Mayor Tom Mulligan, absent. Ken Vanborg, absent. Joyce Farmer. Here. Ron Hammond.
Here.
Bill Hoffler, absent. Mark Hoer.
Here.
Jim Hurley, absent. Barbara Koch. Here. Janet Leonard. Here. Bob Schaefer.
Here.
Kim Rose.
Here.
Chairman Blair.
Here. So the record shows we have a quorum.
Yes, we do.
And our first order of business is a resolution. We've all received copies of the resolution in our packet before the meeting. It's LUB 100, Ridgeview of Rockaway. Will someone please make a motion regarding the resolution?
So motion to approve.
We have a motion to accept the resolution and a second.
Second.
Is there any discussion? Seeing no discussion, may I have a roll call vote, please?
Joyce Farmer. Yes. Ron Hammond.
Yes.
Mark Hoer.
Yes.
Barbara Koch.
Yes.
Janet Leonard. No. Kim Rose.
Yes.
Ken Blair.
Yes. Thank you very much. The motion is accepted as written. I want to thank you very much for doing such.
So written and rewritten.
And our next order of business is application LUD 103, Milco Realty. We have received our packets with all of the pertinent documents that were supplied by the applicant before the meeting. And we've all had the opportunity before the meeting to visit the property. So, Counselor, I will turn it over to you.
I have to push the button, excuse me. Thank you, sir, Mr. Chairman. Ladies and gentlemen, my name is Roger Thomas, the law firm of Dolan and Dolan. Can you hear me okay?
Yes.
Okay. I am representing Milco. This, as you know, at least I assume you know, is a fairly long and tortured application. It was the subject matter of a prior, excuse me, the worst thing that can happen to an attorney is losing one's voice, and that seems to be what's happening today. But in any event, just one other verification, it is my understanding from your secretary that there are 7 members that are currently eligible to vote tonight. Am I correct about that?
That's correct.
Thank you very much. So that this is a matter that was the subject of a prior resolution that was approved by this board in 2018. It had, as is usually the case when I represent boards, there are usually conditions. There were conditions as part of this application. Some of those conditions involved the impact of outside agencies. They included, at one point, the DEP. They included the county of Morris, as well as, I will call it an outside agency. It's really the railroad that abuts this property. I can tell you that because of those outside agencies, my client has spent a considerable amount of time, effort, and money trying to get through those outside agencies to be able to get you to this point in time. There has been any number of communications with those entities to try to indicate that we believe we have a good access with regard to the matter. I have, as part of the application, sent you what was then a group of emails from those entities to our engineer, who you're going to hear from tonight, indicating the back and forth that has occurred, at least as far as the period of time that I've been involved. I have, frankly, more, which I don't know that you're going to necessarily want, but I have more emails that have occurred in the last couple of days, and then I have some emails that have occurred over the last 2 or 3 days, which are going to be relevant, and I'll talk to you about them when we get to the witness. What we are here today is to try to get an amendment to the application. There are a couple of things that have been outlined by both your engineer and your planner. We plan to be able to address those. We think we have some concurrence, we hope, with regard to the outside agencies. We think that we are in a position to present a plan to you tonight that we believe will allow us to move forward and satisfy the concerns that were raised at the prior application process. It's been a very long and tedious process for my client. It's been a very long and expensive process for my client. I want you to be aware, however, that he has not sat on his hands doing nothing. He has been working diligently, and I can tell you that I do know that the engineer, Mr. Reagan, who is going to testify, will testify all of the efforts that he's made to get us to this point. With that, I would ask, unless you have any questions of me, I would like to then present Mr. Reagan, who is the owner of the property.
Remain standing, raise your right hand, please. You solemnly swear the evidence you are about to give before this board should be the entire truth,
Yes.
and identify yourself for the record, please.
My name's Thomas Rankin. I'm the owner of Milco Realty, which owns the property in question.
Thank you.
All set?
Yep.
We'll share the mic. Tom, how long have you owned the property?
Milco's owned it since the 70s, I believe, but I purchased Milco in 2008. I was a tenant before that.
Okay. And when you purchased the property, you were familiar with the activities that were going on the property, correct?
Yes, and I purchased the company.
I understand.
Yeah.
And I say the property, you're right. You purchased the company, not the property. Okay. So the fact of the matter is, excuse me, you were familiar with the activities that were going on the property, correct?
Correct.
Can you just briefly describe what those were prior to taking ownership of the company?
I mean, it is and was a multi-contractor yard, as well as predominantly a police impound yard, so.
And since
What
you,
impact, I'm sorry?
Police impound yard, or I believe that's the right term.
I think it is the right term, and for whom is that impound yard benefiting? Is it for the borough?
I guess the community around, the community and the borough, I'm sure.
And since you have acquired the property, have you changed any of the activities that you were aware of from the time that you got involved? And as a matter of fact, let me rephrase the question. You said that you were familiar with the property from the 1970s, correct?
Yes.
And have you changed any of the activities since you've been the owner of the property that have occurred on the property since the 70s through the present time?
It's continued to be a multi-contractor yard.
Okay. And you were here back in 2017 and 2018 when there was an application that came before this board, correct?
Correct.
And there was ultimately approval. You remember that?
I do.
Unfortunately, you also remember that there were conditions.
Yes.
And you, briefly, can you tell us the efforts that you have made in terms of acquiring individuals to try to help you satisfy those conditions?
I mean, some of the conditions were easy enough, with, identify a pipe or put filters in along an inlet, things along those lines, those were done. But the sticking points were the ones where the outside agencies come in. The DOT was involved at one point, the DEP was involved, the multiple railroads, they sold the rail line, we were in communications and it changed to a new rail line. The county, and really that's been the greatest sticking point in trying to keep it where the tow yard can stay in business.
And in fact, during that period of time, of course, we ended up having something known as a pandemic. Did that have an impact on your ability to try to continue to communicate with all these outside agencies?
Absolutely, we barely kept the doors open, quite frankly, so it was a difficult time for everybody, and yes, we had a hard time communicating, nobody wanted to communicate.
And so you, to the extent that you could, you did attempt to communicate with these outside agencies, and because of their limited access and their difficulties dealing with the pandemic, you were having some difficulty in terms of getting responses, at least during that period of time, as well as before and subsequently, am I correct?
Yes.
Okay. If you get the approval that we are seeking tonight, do you have any plans of changing your operation in any way, shape, or form that's going to affect the traffic patterns, other than the slight relocation, which will be discussed by John Regan? Other than that, are there any plans that you have for the future in terms of traffic volumes regarding this site?
No.
You're going to continue to operate as you have since you've acquired the property?
Yes.
Okay. I have no other questions of this witness. Thank you.
Do our professionals have any questions for this witness?
You have to stay for subject to cross.
I just have one question for this witness. The uses that are on site that you testified about, you called it a multi-contractor yard. Do you have the zoning approvals for all the uses that currently exist on the site today?
I believe so.
Thank you. I have no questions.
Okay. Any questions from the board members? Yes, ma'am.
Hi, so, it's been 6 years, summer 2008, and now you're coming and want a relief from for example, the fence. What's happened between now and then that you never came before us for the fence and the
Let me respond to that. The fact of the matter is that we are seeking clarification, and you're gonna hear that clarification that is taking place. What has happened is part of your application process. You will see that there's a whole series of emails that have occurred between the engineer that's been hired by Mr. Reagan, as well as, I believe there's some by me, but more importantly by Mr. Reagan. And he has attempted over the course of the last, at least the last 2.5, 3 years that I've been involved, and I think a lot longer than that, to try to communicate with these outside agencies. And they have, for whatever reason, they have either told him, we'll get to you, we're not happy with what you're doing, or mostly they just have not responded, either because of the pandemic or otherwise. We have had a situation whereby I've been in municipal court on several occasions, indicating to the judge that we are diligently working to try to resolve these matters, and the court has given us the leeway, thankfully, to be able to allow us to continue to work. We're going to have testimony by Mr. Reagan as to what efforts he's made, not just in the last couple of weeks, but over the last number of years, to be able to get us to this point. As I've said to you earlier, and as Mr. Rankin has just testified to, he has not sat on his hands doing nothing. He has worked diligently to try to end up getting these approvals from these outside agencies with a great deal of difficulty, and it has now only been in the last couple of weeks that there's been some movement on their part. I can't explain why they have chosen to wait so long. I know that Mr. Regan has been working very hard over the last 2 or 3 years to try to get these approvals, and he has had a very difficult time dealing with it. So I wanted to be clear not only to you, but to all the members of the board, as well as the public, that Mr. Rankin and Milko, my client, has not sat back and done nothing. They've been working ever since this approval, and they continue to work, and we think we're very close to that point where the railroad and the county seem to be on board. We don't have a verification, but we think we're close.
What does that have to do with putting a fence up on the back of his own property?
There are 2 fences, and we have an answer to that question, and we'll tell you that answer.
Not the one alongside with the train track.
I understand
The one
that.
across the back of the property.
We have an answer to that question. If you
I
just
hope so,
give
because
it,
that shouldn't be put up.
let me just answer that question through my engineer, and I'll be happy to do that. We think we have a better answer than what was proposed at the original approval back in 2018.
Any other questions from the board? Anybody from the public would like to make a question to the witness, what they've just heard testify? This is a time for you to ask questions about what was just said, not to give your opinion or state a fact.
I mean, this may be a bit rhetorical, but he says he has no plans as of right now to change the traffic patterns.
We need
No,
your
that's
name,
not-
your name and
not
where
yet.
you live, please,
Okay.
sorry.
Not yet,
No,
okay.
come, you,
No, I
want
mean,
a
that's my
question?
question. I mean, will his opinion change in like 3 to 5 years? Like, is this gonna, I mean, is this forever?
We need to say who you are first,
Okay.
please, and where you
Sorry.
live, sorry.
Oh, my name is Valerie Piakowski. I live at 66 Top Street. So my concern with saying that there are no plans to change the traffic right now.
So you're questioning his question?
I mean, is there gonna be something that's put in place, like some kind of amendment that's holding?
So you're asking him if he's planning to put
Right.
something in place to assure that he doesn't increase the traffic in the neighborhood?
I would like
Let
some
me try to
assurance.
answer the question if you don't mind. Do you have any plans in the foreseeable future to change your operation that's gonna measurably increase the traffic on your site?
That's not my question, in all fairness. My question is, what assurance can you give us that you will not change your mind to increase the traffic flow of our neighborhood?
I don't know, I have no plans to, I don't know what would make me do that, if I sold the property or sold the company, would someone else do something?
I mean, that's
Potentially.
just
I don't know
a
what
concern
that-
as a resident, like,
Sure,
long-term.
I just wanna continue to run the businesses that are there and, continue to, run it as a real estate holding company and, I don't have any plans to increase traffic.
okay.
I just
Mr.
don't.
Rankin has made a representation that he has not increased the volume and will not increase the volume, and that representation will be captured in any action this board takes.
Okay.
I'm sure as the attorney, you will capture that very adequately.
One can only hope.
Thank you very much, ma'am. Any other members of the public? Seeing none, we close the meeting again to the public, and it's back to you, Counselor.
Thank you. I'd like to have,
Oh, excuse me, we have a question from a
Oh.
board member.
sir,
Just going by the timeline with all the emails and the letters, and I documented, a lot of that was in 2024 and 23. The approval was in 2018, and the pandemic did start to 2020, so you had 2 years in between. What were you doing at that
There's
point?
emails from them too.
Yeah,
Yeah, with the rail company and trying to get it squared away, with different people, different professionals.
okay, because there's a block of time right there.
and I will be happy, quite frankly, I've only been involved in the last 2.5 years. There were other attorneys that were involved before me. For whatever reason, they left and I took over. Now, I don't have access to all that material. If, as a condition, you want to end up having me find all of those emails from back 2019, 20, 21, 22, and 23, I'm happy to do that, because I'm sure they exist. I just didn't have access to them, and I wanted to get this in front of the board, and I gave you the materials that I had, so that you had an understanding of what was going on, at least during the period that I was involved, and I know that Mr. Reagan was involved. He may be in a position to be able to testify a little bit more in terms of what activities occurred during the period that you're concerned about. But if you really want to have a condition, I would have no objection to burden the record, and it's okay with me, to have those emails provided.
I just want to see that there was movement trying to comply with the conditions of the original approval. For 2
And
years,
the answer to that is yes,
Because you're just showing the
absolutely.
last year and a half of.
The answer to that is absolutely yes.
Okay, that's what I need to see. Okay.
Yes, sir.
I just want to put on record that there was like 2.5 years before any action was taken. And the only reason I believe action was taken is because we as the board asked the zoning officer to look into it because nothing had been done. We went over and looked at it because we're allowed to as a board. And there was a bunch of stuff that had to get done. And none of it was done. None, absolutely nothing. There was no fence. There was no fence along the side. There was a lot of things.
Cleaning up from the dumping,
Right.
to be removed.
There was no relief from the dumping. And we asked the zoning officer to look into it, and the zoning officer started bringing it to court. And that's what caused the action to be taken. There was no action taken.
The noise starting at 6 a.m. and having the neighbors call it down constantly.
There was no action taken until we asked the zoning officer, because we don't have the ability to be enforcement. But we asked that, we noticed there was nothing going on in that site, and asked the zoning officer to look into it. And that's when stuff started to happen. I'd just like to make a comment, that's all.
Seeing none, sorry, Counselor, back to you.
Thank you very much, Mr. Chairman. I'd like to call our engineer, Mr. John Reagan.
Good evening, everyone.
Mr. Reagan, if you raise your right hand, you solemnly swear or affirm the evidence you're about to give before this board should be the entire truth?
Yes, I do.
And you've already done so, but identify yourself again, please, for the record.
Yes, my name is John Reagan. I'm the principal engineer of Reagan Engineering. My place of business is 56 Radke Road in Randolph, New Jersey.
I don't know, have you appeared before us before?
Many, many years ago.
Why don't we end up qualifying you very quickly? John, can you give us the background of your qualifications as a professional engineer in the state of New Jersey or any other state that you may be licensed in?
Sure. I obtained a Bachelor of Science in Civil Engineering in 1984 from the University of South Alabama. I'm a licensed professional engineer and professional planner in the state of New Jersey for over 30 years. I have appeared as an expert, providing testimony before numerous entities and jurisdictions, providing expert testimony as an engineer, as a planner, and in land use.
And in fact, you are licensed in the state of New Jersey and your license remains in full force and effect?
That is correct.
And you are a licensed professional planner in the state of New Jersey and your license remains in full force and effect?
That is correct.
Are you licensed in any other state in either of those areas?
I'm a licensed professional engineer in Pennsylvania as well.
Okay.
Thank
I
you.
would offer him for...
Thank you, we're more than happy to accept you as an expert in your field.
Thank you, sir.
Will we be getting planning testimony and engineering testimony, Mr. Thomas?
It's primarily going to be engineering testimony,
Okay.
but there may very well be some
We'll
response.
we'll see how it unfolds.
Okay, we'll see.
Yep.
John, if you could indicate, how long have you been involved in this project?
I was engaged by Milco in the third quarter of 2021.
Okay. So in 2021, and again, I'm not asking you to go through a day-by-day activity, but what activities did you take on in 2021 when you were retained? Let's remove that question. What, if anything, were you made aware of any activities that may have occurred prior to your involvement through any conversations you had with Mr. Rankin?
I was advised by Mr. Rankin that there were open conditions of the resolution of approval from 2018, and that he had desired my services to help him navigate those conditions as a result of his not fully understanding everything that had transpired in the past with his prior professionals, and asked for my assistance with helping him to navigate those conditions.
And without getting necessarily into the specifics of what transpired between his prior professionals and him, you have indicated that you were advised that there were prior professionals working on this matter after the approval that occurred in, I believe it was January, but whatever the month was, in 2018, correct?
Correct.
Okay. And then you became the engineer involved in 2021. What activities did you yourself engage in regard to the various conditions that were part of that approval?
So there was a site plan that was approved that had a number of conditions related to various items. Inlet filters, drain pipe location where it terminates towards the rear of the property. Obviously, the railroad right-of-way issue, the fence at the rear of the property, citing a dumpster at the property. Handicap parking needed to be assigned. So there were a variety of items that needed to be addressed.
Okay. And what activities did you engage in an attempt to try to address those, either through contact with outside agencies or with contact with anybody else that you thought was necessary to move this project along?
Well, based on my professional judgment, when I saw there was the condition of the railroad and how that potentially could affect the property, I engaged communication with representatives of the railroad because, in my opinion, until that issue was resolved, some of the items of the site plan as well as other conditions of the site plan and approval would be contingent on the outcome of that resolution of the railroad right-of-way. So early on in my engagement in 2021, I reached out to what ended up being the prior railroad, I believe it was the Morrison Erie Railroad. And then after attempting to contact them, I advised that the County of Morris had acquired the right-of-way and that they had changed operators to the Chesapeake and Delaware Railroad. So then I reached out to the county and I reached out to the new railroad, spoke with the executive vice president of the railroad, who then put us in contact with like a third party that manages the rail for them, and that started a long series of communications. I had site meetings with a representative of the railroad. That representative made recommendations with respect to certain improvements that they thought should be made within the right-of-way, curbing, pavement improvements. I had prepared a plan that was reviewed by the County of Morris, that was conditionally approved by them, but subject to the railroad's approval. The railroad ended up not approving it and actually denying it, and then engaging the New Jersey Department of Transportation to get their input into the proposed improvements. Long story short, had a meeting with the county, the DOT, the railroad. This was a virtual meeting in December of last year.
Before you get there,
Okay.
and it is a long story, so I don't know that we necessarily are gonna make this a long story short. But the fact of the matter is, you said that when you got involved, you were aware that there were certain conditions that involved the railroad that you said might very well affect the functioning, my word, functioning of the operation as you understood it, as given to you by Mr. Rankin. Is that correct?
Correct.
And in fact, was one of those concerns that you had at the continued viability of the impound lot that is currently on the site?
Yes, because if the current circulation pattern utilized by local tenants was affected by the decision of the railroad, that would affect the use of the remainder of the property.
And therefore, again, as has been suggested by the attorney, you are a professional planner, and do you believe that the impound lot is an activity that benefits maybe the surrounding areas, but certainly, as you've come to learn, it benefits the borough of Rockaway, does it not?
It's my understanding not only the borough of Rockaway, but other surrounding communities as well.
And the failure of that impound lot to continue in its operation undisrupted would adversely affect health, safety, and welfare, would it not?
Yes.
Okay. You then indicated that there were new conversations that you had with regard to the railroad. You already indicated that you had to go through two different railroads, not just one. Is that correct?
Yes,
Okay.
correct.
Now, I want to address one thing sort of early on, if you could. You were concerned that in order to really make this project work, you had to deal with the railroad first and the access. Is that correct?
Yes.
And therefore, anything else would not really benefit anyone unless you got the railroad on board. Is that the thinking that you ended up having during this whole process?
Yes, it was a substantial part of my professional opinion as to how these issues needed to be navigated.
Okay. There was a comment made by one of the board members with regard to the issue of a fence. You're familiar with that fence? As a matter of fact, there's two fences, is that correct?
There is a requirement potentially for two fences.
Okay.
Correct.
And I'm not talking about the fence along the railroad, I'm actually talking about the other fence. And maybe you can describe it better than me than saying the other fence. What was the intent of that fence as you understand that resolution?
As I understand the approval and the resolution, there was, and shown on the site plan, a 6-foot high chain link fence, which was proposed across the majority of the rear of the property, intended to create a separation between the edge of the bank of the stream. I guess there's had been some past history there with the operations, and that was a requirement of this board and the condition of approval.
Okay. And in fact, would it be possible, as you understood it when you got involved in 2021, for Mr. Rankin to just simply put up that fence, or did he need another outside agency approval before he could do that?
There is a requirement for approval from the DEP to place that fence because it's within a wetland transition area.
And were there activities in terms of trying to deal with that issue as well?
Yes, I communicated with representatives of the New Jersey Department of Environmental Protection, initially attempting to gain the approval for the placement of the fence at that location based on the specifications shown on the site plan. I was advised by the representative of DEP that they would prefer to see an alternatives analysis, meaning was there something else other than a permanent fence that could be constructed in the wetland transition area?
And that was not something that you were advised of the first or second or the third conversation. That was after ongoing conversations with the DEP. Was that correct?
Yes, it was a little ways down the road.
Okay.
Yes.
And so do you ultimately now, as part of the plan, propose an alternate method of dealing with the issue that was involved as part of the resolution, i.e. trying to assure that trash is not thrown over into the brook or the river?
Yes, so based on engaging DEP in discussing this item, I was advised that a vegetative buffer, planting of native trees along the same location where the chain link fence was proposed would be an acceptable alternative to the DEP and actually would not even require a permit. That's something that the applicant, if it was approved, could do as soon as possible.
Okay. And that's what you're proposing, as I understand it, as part of this alternative plan that we have in front of the board now?
Yes.
Is that correct?
Yes.
Okay. Now, from a planning viewpoint, again, you are a professional planner, do you believe that the alternative of a landscape buffer is better than what had been proposed back in 2018, which was a chain link fence?
I think it's a more aesthetic improvement. I think it could also serve as the barrier that I think was the intent of the chain link fence. The vegetative trees that would be planted there would start in the 5 to 6 foot height range and then grow from there. The original site plan required a 6 foot high chain link fence. So I think that from a screening standpoint, a barrier standpoint, I think it's a better solution.
And in fact, although we wouldn't be willing to work with either the engineer or the planner of the borough in terms of establishing the nature of that barrier, you're willing to work with them in terms of if there needs to be some staggering so that there's no area in between the trees during the growth period.
Yes, within reason, because it's a very constrained area along that stretch to make sure that the fire truck access can make it around and things of that nature. So, recognizing those site constraints, yes, certainly happy to work with the board of professionals.
All right, and that is something that you have just been able to, I don't want to use it, well, I will use the term, negotiate with the DEP and be in a position to sort of get their concurrence that that's a better idea than a fence, with the approvals, with the permits, with all the activities that are involved with the DEP, correct?
Yes, and the concurrence from the DEP occurred in 2023, so after, numerous back and forth with them about the occurrence analysis and things like that, it became acceptable and that the vegetative barrier would be something that the DEP would accept.
During that period of time, you continue to work with the entities that you were dealing with the two railroads, the county, and what activities did you engage in from, now we're talking 2023, 24, 25?
So I'm continuing to deal with the representatives of the county, the railroad, to try to resolve the right-of-way issue. Again, the resolution required that if the approval of the railroad wasn't achieved within a certain amount of time, a permanent fence needed to be placed there as well. So again, that would require a different type of approval from DEP, similar to the chain link fence that was shown. So again, there's a cause and effect relationship that would affect the site plan. So
you couldn't do the one without the other?
correct.
Okay. So you continue to negotiate with them?
Mm-hmm.
And you have seen some of the things that I have provided as part of email chains that have gone back and forth between you, the representatives of the county, representatives of the railroad.
Yes.
Correct? And are they reasonably accurate representations of the efforts that you've made, not only during that period that I've submitted them in terms of 2024 and 25, but also during that earlier period in 2023 or even 2022 and 2021?
Yes. Yes, there is a continuation of my efforts.
And you've worked on this project continuously since you've been retained by Mr. Rankin during that whole period of time. Obviously, he's not your only client, but you've been working on it throughout that whole period, correct?
Yes, that's correct.
Now, we have submitted a plan. That plan is already, it's now been, it's in front of the board. I guess what we can do, Mr. Chairman, since it's rendered, it's the same plan that you have, but it's a rendered plan. Maybe we can mark that as A1.
We'll make that A1 with today's date, please, and that will be the same as is handed to the
Same
board,
plan.
it's been colorized
Yes,
for
same.
clarity.
And I'll mark it.
Thank you very much.
Why don't you discuss that plan, and then we're gonna go to where we are now,
Okay.
and how this continues to always evolve.
Okay. So
I have a question, excuse me. You started talking about a meeting you had last year, in what, December of 24?
yes.
And then we decided to have more conversation for in between. I would like to hear about that meeting.
Okay. This kind of ties into this plan.
Okay.
So the meeting came about because I kept following up with representatives of the county, being the owner of the railroad right of way, and that I needed to get a resolution from the railroad operator as to what could reasonably be accomplished here. The use of the property and the railroad have coexisted for well over 100 years.
How do you know that?
Based on historical Sanborn maps, which are insurance maps that were kept for a long time. So there are Sanborn maps that go back, I think, to 1904, if my memory serves me correctly.
And if I can, to bore everybody to tears and get into a whole series of legal things, in fact, the Sanborn maps that you have indicate that Cobb Street, which is what abuts this property, correct?
Correct.
Actually, Cobb Street was, it dead-ended. Dead-ended. And it dead-ended at the railroad, is that correct?
Correct.
All right. And it's clear from the Sanborn maps that this property and the activities on the property were in existence back at that time.
Correct.
And that continued under that circumstance, based upon the historic record, until, and I may be wrong, because you and I talked about this some time ago, but wasn't it until around the 40s when Cobb Street was extended?
I believe that's accurate.
So therefore, and Cobb Street, as far as you know, is a borough road?
Yes.
Okay. And therefore, once Cobb, and this property had access to Cobb Street during that entire period of time.
Yes.
And therefore, once the railroad, or strike that, once Cobb Street was extended beyond the railroad in what would be, if I read the map correctly, in a northwesterly direction, presumably that same right would convey to not only the borough, but it would also be to abutting properties. correct?
Yes,
Based upon your understanding.
yes.
But yet the railroad and or the county didn't see it that way.
Not till I brought it to their attention. So to
So-
continue,
Yes, please.
to continue with the December meeting, that's some of the background that I shared with them at the December meeting. So the railroad operator, Chesapeake and Delaware, engaged the New Jersey Department of Transportation in providing an opinion on this matter because the New Jersey Department of Transportation also has a rail safety division. So they wanted their opinion as to this property and this driveway location. And so one of the things is that tan area there that's shaded, that's an ingress and egress location that's been in existence by Milco and by Mr. Rankin's company since the time that he's purchased the company. And so my initial conversation with the railroad going back to the beginning was, and based on what I understood the resolution says, I was seeking just to have the railroad provide an approval that the use that's existed there for a very long time is allowed to continue. That just seemed to snowball. So I have to give you some more history. So before the December meeting, well before that, probably in that 2021 timeframe, the railroad, Chesapeake and Delaware, sent an individual from the railroad who came out and met with myself and Mr. Rankin as well, and said, it'd be better if you put curbing within 2 or 3 feet of the railroad ties. It'd be better if you pave it. It'd be better if you do these things. So I prepared a draft plan. I submitted it to the county first to see if the county was accepting of it. The county was accepting of it. Then I submitted it to the railroad. It went quiet for a while, and then I kept following up. Finally, at some much later date, I get a response back that that's not acceptable. Long story short, so I had the meeting in December saying, I would like to maintain some access around the building. There was not a meeting of the minds at that December meeting, and I said, I think we have a January court hearing coming up. I said, the borough and the court keeps asking for me to demonstrate something. I have to show something. So I quickly prepared this plan saying that green area is what I was proposing as to maintain the circulation around that existing building, and this small area here overlaps into the railroad right of way, but it's necessary to maintain vehicle traffic, and I showed a fire truck, Rockaway Borough fire truck being able to make that loop, as well as for the remainder of that tan area, there's parking of vehicles, there's storage of materials, things that have gone on for a long time. So the representative of the DOT said, give us a few days, we'd like to consider this and we'll get back to you. I think that on December 10th of 2024, I get a letter from the County of Morris saying they conceptually agree, however, they are waiting for the DOT. Fast forward, so this kind of sums up the December meeting. Fast forward, I get no response from the DOT, I follow up the county's following up the DOT, no answer. So just within the past couple of weeks, we had another court hearing coming up on March 24th. I reach out to the county and say, we've got this court hearing, I have to, again, represent to the court, to the borough, something's happening. So I get called to the county's engineering office, I think it was last week, and they get a representative of the railroad on the phone, and so I go through, explain everything again, and the history, and they say, oh, well, we don't want any permanent improvements within the right-of-way. Other than that, we can conceptually agree. And I say, the only reason why I proposed those permanent improvements was because your representative told me back 2021 that's what they wanted. Oh, we're sorry. So what I quickly responded and said, the one concern they had, which is they do not want any more access to continue down within the railroad right of way. So I consulted with Mr. Rankin. He said he's fine with eliminating that. They want possibly fence, so there's an existing fence across the front of the property, just to extend that fence to prevent that access. And I shifted this green driveway just slightly away from the railroad waterway, because there was a small corner that was catching it. And I submitted it to them, and I had some email correspondence, which I think Mr. Thomas has for you. And conceptually, they agree now. So now the executive vice president of the railroad is going to work on a lease agreement, kind of memorializing these things with some stipulations as to what the requirements are. But it seems like we have a meeting of the minds at this point with respect to, they will allow the continued use and occupancy of the railroad right away as it has been for a long time, with the agreement to close off this stretch here and just shift, which is kind of the existing entrance anyway now, into McCarter's Towing. That would be the main entrance used by all tenants within the property.
Understood, thank you very much. I do have a question. Somebody said something about they didn't want, there would be an issue, there would be an issue with the towing company. What was going to be the issue with the towing company?
I don't.
The issue that I raised is with regard to the fact that the towing company, if it turned out that some loop arrangement or similar traffic pattern that had previously been in existence had to be substantially impacted, therefore they would no longer be able to utilize this site and there would be a disruption in service. Is that what your understanding was?
Yes, so based on my conversations with Mr. Rankin, that if this portion of the property was severely constrained because of not being able to continue the access around, he would have to strongly consider not renewing the lease of McCarter's Towing, because the operations that occur there now would have to in part use some of the area that McCarter's is in now.
Well, if that's something that did happen, we are not policemen for whether or not Carter's Towing stays or goes. Just wanted to put that out there.
I'm sorry, I misunderstood what you said. I apologize.
The board is not, in charge of, whether or not Carter's Towing stays.
I never represented it.
We're trying to get what he needs so that he can get and make Carter's Towing moving, not the health and safety of anyone.
I never offered the fact that you were in charge of anything in terms
It
of.
was inferred it might
No,
disturb the health and safety of the area.
Just so that you understand my argument, it is not the fact that you are in charge of something that's going on with regard to the towing company. What I'm saying is very simple, that in fact, if this could not be worked out in a manner by way of the access that is acceptable, then McCarter, I didn't know the name was McCarter, but McCarter Towing would then have to be relocated.
Yes.
And therefore, it would be an adverse impact because it would be disruptive to the not only to this community, but to surrounding communities, and therefore that would be an adverse effect on health, safety, and welfare, because we don't know where they would end up ultimately going.
There's lots
That's
of
the
places
argument.
they could go.
Well, that may or may
That's
not be true. I can't answer that question, and respectfully, I don't think you can either.
No, I can't, but it's, if they moved, it's not going to impact the health and safety.
Well, that's
We
up
can
to,
agree to disagree.
that's my argument. Yes, sir.
You're saying that the change that the railroad company has told you is basically the straight strip of property on this easement from Cobb Street to where the curve is gonna be eliminated.
So
That's what their addendum to it.
they're asking that vehicles no longer enter and
Right.
exit from there.
Right, because right now, I know you're saying it's an impound yard, right? But you can walk in off of Cobb Street through that side. If your car was impounded and you had a key, you could put the key in the car, you could drive it out through the side over there, because it's not, the impound yard is not enclosed, because that side is wide open. You know what I mean?
Yeah, I understand, yes, you're correct. I mean, if you walk down here, you could walk around and get into the impound yard.
Yeah.
Right, right.
What? No, I know that, I'm just saying, it's better that piece isn't there. It's better that piece isn't there. And then you're gonna extend the fencing?
Extend the fencing, which would eliminate that ability.
Yes, then when the gates close, the site would be closed. It would be much better.
Yes, sir.
May I
I jump in with just some clarifications? Do you have a site plan that you're going to propose tonight that shows where all of these various improvements are?
Did I prep you for that question? I guess I did.
I think I don't know about the rest of the board, but
No.
Golden and I are talking here, we seem just a little, we've gotten a lot of backstory, we've heard about a lot of meetings, and, I'm following the conversation, but I think without a plan that shows exactly where these things are proposed, we're kind of all grasping at straws a little bit here to conceptualize exactly what you're asking of all of us.
And that is exactly where we're going next.
Great, I think let's get to that next, because I think we're all
Well, hold on. In order for us to be able to get to that point, I think it was important fundamentally to be able to answer some of the questions that are in the minds of the board members that needed to be answered. So we needed to do all of that, in my opinion. I could be wrong, but that was my opinion. So I'm the one that directed that, and I think that that was important to be able to do. Now, it turns out, as you've seen, there are a whole series of emails. I've got a lot more that I could offer, but I'm going to offer and have Mr. Reagan identify the most recent ones as a result of the meeting that he had last week. And that is the email that I received, oh, by the way, today. And what's in that email that's relevant? Well, there's a lot of things that are relevant, but if you flip over, John, is that the plan that is now in front of the county and the railroad? And if it is, and I apologize, it's not rendered because I don't have that capability, but the fact of the matter is, can you tell us what the difference is between the plan that's up on the board and that plan?
Yes, so what Mr. Thomas is referring to is a March 26th. I took an excerpt, a screenshot of this entrance area, just so I had a conversation, a meeting that I had at the county last week, just to...
Can you hold the phone 1 second? It's an email from whom to whom?
This would be an email from John Reagan, myself, on March 26th. Okay, well, there's a couple, there's a thread here, so, let me strike that. So there's a March 26th email that I send at 9:02 a.m. to Kane Baranga and also Catherine Banks, who are representatives of the railroad, the Assistant County Engineer Rosalind Curtin, John Hayes, also with the County Engineer's Office, Kevin Stevens, and basically I'm summarizing the meeting that we had the day before. And as part of that summary of that March 26th email, I prepared an exhibit, which is dated March 26th. And basically what it's showing is moving that driveway entrance there just slightly southeast away from the railroad right-of-way, because there was just a small triangle that was catching part of the railroad right-of-way in the plan that you have before you. So they asked if I could move that driveway out of that small triangle area, which would make the plan acceptable to them. And so I tried to demonstrate to them by moving it slightly that I could accomplish that.
Mr. Reagan, I have a couple of questions. First off, do you reference an open court case? Is that court case still open?
It is.
What does that reference?
Matter of fact, I asked for the case to be adjourned, subject to this hearing, and your zoning officer concurred.
So is it closed? Is it adjourned?
No, it's not closed. A lot will depend upon the outcome of tonight's meeting.
Still open. So do we have final approval from the county for that site plan?
We do not. So
Do we have any type of final approval from the railroad for this site plan?
we do not at this time.
So, hold on. What are we doing? If they don't have final site plan, they don't have any final drawing, we're not gonna be able to vote on anything here tonight.
Well,
I
respectfully,
don't
I
know that
disagree.
approval's needed to cease and desist or trespass on railroad property.
No, I agree, but then we need finalized plans from the other agency before we can vote.
That would be up to the discretion of the board, but I would think that you would wish to see, and our professionals would wish to see, a final formal site plan. Is that what you're asking?
Yes. Or finalized plans from the county and also from the railroad saying, hey, we agree that you guys can do this, and then we approve it.
So, if I can offer.
Okay.
So this is a amendment to 3 conditions, is kind of the scope of this. One of them is about a rear fence, and you're offering a solution about vegetative trees that I don't know the distance or the width of that buffer, or what you're actually showing.
What species.
One is about removing a condition, let me just. One of them is about removing a condition of either the fence with the right-of-way or some kind of approval from a right-of-way, which I don't know if we're premature right now. You testified you're kind of on the brink of some kind of resolution, but we don't have that resolution at this moment. And then third, which I don't know if we're gonna get to this testimony yet, is about moving a trash can, which I haven't heard yet about that. It just seems of these 3, it really does come down to what is your alternative, and are we premature at this point?
Well, let me answer all those questions by simply responding as follows. This matter has been the subject of litigation instituted by the borough against my client. And it has now been adjourned probably 4 times, based upon our representation that we're still working very hard with the county, with the railroad, and to get these people, this is a legal phrase, off their butt, to be able to get us to this point. And we've now gotten to the point where we think we are reasonably close. And I'm sure I do not have to instruct any of you, because you're all, look to me like members who have been around and have an understanding of what's going on. You have the right, and in fact you did it in this case. You granted approval based upon the outcome of outside agencies. You do that all the time. I represent 15 boards around the state, and I do it all the time, and I'm sure your attorney does it all the time. So there's no question that you have that authority. But to answer your specific question, what is the urgency, and I'll use that term, the urgency is that there's this litigation that has been pending for a period of time, and now I've been told by your representatives that unless we do something, that he's going to start fining my client to the tune of $1,000 to $1,500 a day, unless we are in a position to be able to come before the board and make some proposal. That's why we're here. Is it premature? Do you have a site plan? No, you do not. Am I free to admit that? Absolutely. Are we here to be able to explain to you what we're proposing? Absolutely. In another minute, I'm going to be offering as A2 this additional email chain, which actually will show you, by concept, I admit, by concept, the alternative plan. It is not dramatically different. Frankly, it's an outrage that in fact we had to wait 5 years to be able to get to this point to move a access 8 feet, 6 feet, roughly. I mean, is that unconscionable? In my opinion, it is. But I have no control over that agency, and neither do you. So we're trying now desperately to come in so that we're staving off what amounts to in our opinion, an unreasonable position to say that we're going to be fined, notwithstanding the efforts that have been made by my client. So now I'm going to offer, as a series of emails to which there is attached a concept plan, and if it means that we end up getting an approval subject to the submission, subject to your planner and the engineer, of this concept plan, and also that we have an approval subject to your engineer and planner of the natural barrier, which I'd like to think that your engineer and planner will agree is better than a chain link fence. I mean, I have nothing against chain link fences. Quite frankly, they're not terribly aesthetically pleasing. So that's what we're looking for. And in terms of the issue of the trash enclosure, we're more than happy to end up working with your professionals to say, sure, we'll be happy to put in a trash enclosure in a location that you think is reasonable, so long as it doesn't interfere with the access. And there's plenty of places.
Has the
There's
railroad,
plenty of places to be able to do that.
has
So
the
I'm
railroad,
happy-
Mr. Thomas, expressed a position on the document in your right hand?
Yes.
And what is that position?
The position is that I'd like to offer this as A2, and what it will show is a concept plan which we can turn into a site plan. We can do that and submit it to you with the idea that we will then continue to work with the railroad and with the county to make sure, as you have suggested, that we do not have that final approval, but we think we are as close as we're ever going to get.
So the answer is the railroad has not expressed a final position yet.
The railroad has indicated not to me, but to Mr. Reagan, that, well, let me put it this way. The county has expressed approval verbally of this concept, and the railroad, and I don't want to put words in John's mouth, but it's my understanding that the railroad has said that they think this makes some sense and that they want to work with John to do some slight tinkering.
What is the county's interest in this property?
They own the right of way.
They own the.
They own the right of way, and the Delaware and Chesapeake is the operator of the rail line. So just to follow up on what Mr. Thomas is saying, so in the email, we'll talk about the railroad operator says that, he's saying that we're in concurrence.
Can you pass this around? Can we see this exhibit that you've been talking about?
As soon as I'm allowed, I'll give it to you, as soon as I'm allowed.
You have a meeting,
Mr. Chairman, can I,
Please, yes.
Mr. Chairman, may I offer this as A2?
Of course.
Thank you.
So you had meetings and you had emails, and the railroad was all kept about, we'll do this, I like that, that's okay. A year and a half to 2 years later, they said, no, never mind.
Yeah.
Okay, so until we have something from the railroad concrete in writing that says we will do this with you and they sign off on it, and with the DEP and they sign off on it, and we know what trees and where they're gonna go and what, I'm not willing to continue with
Is
this.
it just the share?
I'm not.
Is it this page?
Yes,
Anything more than this page?
that's all.
I don't think we've ever voted on something where this might happen and might not, especially since you already had meetings and they told you, no, never mind. So,
Yeah, so, I mean, Mr. Thomas can interrupt me, but I think it, phrase it my way, this what, I had met with Samantha and some borough representatives on site a couple years ago, maybe it was. And, you know, so I've been working with it ongoing, and, you know, as Mr. Thomas represented, and I said earlier, the court keeps asking us to show something, right? So this was an effort to, and it was probably a long time coming, to come to the board and apprise the board of the efforts that were being made over time, and that it hasn't been an easy process.
But let me just, if I
go
can,
ahead, please, go ahead.
what I will say is that I had a suggestion made 4 months ago to come before the board on what's called an informal review, all of which you are familiar with. It's a concept review because we knew we didn't have the final plans. I was told that no, you can't do that. Now, respectfully, I disagree with that position, but it's not my board, it's your board. So I'm playing by your rules, and therefore, I am not coming in with a concept plan. I'm coming in with an amendment that I understand has some issues to it, but we have no choice because of the fact that we're being faced with a penalty that is, in my estimation, unreasonable. We are making every effort that we possibly can. If it turns out that what you're saying to us is that, you know, you first of all, I think you have every right to grant an approval subject to a series of conditions, which is what you did 7 years ago.
What it is you're seeking from us?
I'm seeking an approval for the site plan as outlined in A2, and that there would be the other conditions that are outlined in the 2018 approval, which included, I believe it included some kind of a PVC pipe that's either already been done, just needs to be inspected. The fact that it requires, as I believe it was, I'm not sure it was the engineer or the planner who talked about the location of a trash container. That's a perfectly reasonable one. That's something that Mr. Rankin is perfectly willing to do within a reasonable period of time. We are also willing, based upon what we get from the railroad, which we hope we're at a point where we can end up making that plan, that concept plan, a final plan with the verification from the county and the railroad that they agree that it's a good plan and there's nothing further that needs to be done. And then we can end up planting the trees in accordance with whatever species that you want, whatever height you want, whatever height, and if you want a single or a double row within reason. If you don't like that, then what I would suggest is that you end up, and I know you have no control over the zoning officer. I understand that. But it would be helpful if this board feels as though the presentation that we have made today to all of you has shown that there's been a reasonable effort. I would call it Herculean, but I'll say a reasonable effort to try to satisfy these conditions over the last 7 years, and that this matter be carried until another date, and that you at least communicate. You have the right to communicate with the zoning officer to advise him that in fact you are continuing to consider this matter and that it is your opinion, that's all it is, that further action by way of fines and levies would not be helpful to the process.
Just a question, on A2, is it the proposal of Milco to remove the roadway from the rest of the railroad right-of-way?
So there's not a requirement of the railroad to remove the existing pavement that's there, it's just to block the access with a fence, a gate.
The railroad wants you to block,
Yes, right here. This is,
Okay.
right now, this is used as an ingress and egress as well as this area.
but the A2 exhibit shows the interior roadway to loop over the railroad right-of-way.
For emergency purposes only.
Oh, okay, I missed that part.
The testimony that will not be used as normal access, it's just for emergency uses.
I missed that, I'm sorry.
The question I have for you.
I've been patiently waiting. I think it's my time. I would appreciate if everyone would hear me out. I have a question about who calls the shots. I'm hearing that the railroad right-of-way is owned by the county. So does that, to me, that tells me the railroad has no say over what goes on in the right-of-way. Then I hear that the DOT as recently as last week weighed in. So I'm confused about whose approvals are required and what happens if not everyone is in agreement with that. I'm really confused, I'm struggling with that.
So maybe I can help with that. Mr. Thomas, I don't know if this December 10th, 2024 letter from the County of Morris to me is part of the record.
I don't think so.
Okay, but I'll read you second paragraph of this letter. Upon review of the conceptual ingress, egress, and right-of-way occupancy plan, which is the plan you have before you, the County of Morris has found the plans to be a feasible alternative. However, the county will first need to consult with the railroad operator, Chesapeake and Delaware LLC, and NJDOT's Railroad Safety Unit prior to issuing any formal approval to Reagan Engineering for the draft conceptual plan.
Okay, so that tells me that everyone has a say. True? I mean, if
There-
we just break it down to its simplest components,
They have a say.
everybody has a say, but who, right, who is the ultimate grantor of that authority? If everyone never comes to agreement, does that sounds like this matter can never be resolved? Like, I want to know who calls the shots, whose approval is critical to moving forward, and whose approval is just,
Input.
yeah, more of a recommendation than a mandate.
Right.
I interpret what I just read as the county will be the final arbiter, but they're waiting for the opinions of those other.
Okay, so without the county's approval, we can only make recommendations. We can't force them to come to a decision by some certain date, or meaning I mean you, I mean the the people that own the property, Mr. Rankin, you, Mr. Reagan, you don't have any leverage with them to say, we need to have a decision on this by some certain day. Is that true?
Other than my following up with them and asking,
The
so.
answer is yes, that's true, and that's been the whole problem all along.
Okay, thank you. So that's why we are where we are.
Correct, yes.
Because these three entities all have some input, and until they all weigh in and the railroad send you a letter or whatever their method of communication is, saying they either approve or they suggest that you do, something else, we really, that's what we're waiting for.
Yes.
And we don't know when that will come, and we can't force that by a certain date.
So in this A2 exhibit, which Mr. Thomas handed out, I finally have gotten a time frame from the railroad saying that within 30 days, they're going to prepare a lease agreement for our use. So that, to me, was a huge milestone. I have not been able to get that type of response or commitment from any of these
Okay,
entities.
so then, based on that, is it reasonable to assume that whatever action we might take here tonight, that you'll have a response from the railroad within 30 days? What was the date on that letter again?
Well, no, this is a different letter. The email is,
I think the email is.
It's before tonight.
yes,
So within
it's
30, so if we come to some conclusion this evening with conditions, it's reasonable to assume that you'll have a response from the railroad within 30 days.
You're
Reasonable to assume, and I get that, they're in charge,
I
I
would
get it.
anticipate a draft lease agreement within
A
30
draft
to
lease agreement.
45 days, just knowing how things go. 'Cause,
Okay, and talk to me about the process that happens when the lease agreement comes. Who has to agree to the terms of the lease?
Well, the lease seems to be between the operator, the railroad,
Right.
and Milco.
So that's Chesapeake and Delaware.
Correct.
Okay, thank you.
Great questions.
And also, then it seems to me that we're going through all this, that if, rather than just simply putting a fence on the property line, we're going through all this activity, so are you saying that we would be condemning the property if we force you to put a fence on the property line?
You will be,
But we can't put a fence on the property line. The DEP won't let us put a fence on the property line.
You
at the same
agreed to
time.
put a fence on the property line in 2018 if you couldn't meet the conditions.
Yeah, I just wanna work through this, but the DEP
I'm
won't
just
let us
saying,
do
you
it.
testified in 2018 that if you could not get approval from the railroad, that you would put up a fence.
Right, but the
Whatever
DEP,
hurdles that,
right, but the DEP says no, you can't, so.
Mr.
I
Reagan,
don't-
did you make an application to the DEP for a transition area waiver to request a fence be put up in a wetlands transition area?
I did not submit a formal
So
application.
no formal application was ever submitted, so no formal denial was ever made by the DEP. You had an informal conversation, at which time you said an alternative would be a fence, but you did not make an application. Is that correct?
I did not make an application, however, I made.
So
the
any
department-
time-
well, let him finish his answer. I mean,
He answered the question, it was a yes or no question. Did he make the application or not?
Let's let each other finish speaking.
Did you make the application to the DEP?
No.
That was requested? No. So, anything that you had was an informal conversation via email that was suggestions, opinions, alternatives, but no application was made. So, is your testimony that you cannot put up a fence, or you do not wanna go through the cost to get the application and put up a fence?
My
I'm just
tes-
asking.
My testimony is, will you allow me to expand on that?
Yes.
My testimony is that I consulted with the DEP. The DEP said that it would be highly unlikely that a permit would be granted for the chain link fence as proposed on the plans. They said it would likely have to be submitted as an individual permit application, and that it would likely be denied if there were alternatives, such as the one that I subsequently discussed with Mr. Dench. So, in my professional opinion, the likelihood of the chain link fence being approved as proposed, even under an individual permit, is highly unlikely. So to not so much avoid cost, but to stop all the time taking to go through all these exercises to come up with a reasonable proposal that seems to be a benefit for all parties is a better alternative. That was
Are you
my-
talking about
Yeah,
the
you
back
were-
fence? Or we're talking about the side
We're
fence.
But
talking about
the side fence has the same stipulation, because
Why?
you can't put a permanent fence within the transition area.
How wide is the transition area? How far away from the beer brook is the chain link fence along the railroad?
The transition area is 150 feet, and then there's a riparian buffer that's another 150 feet,
Then his
so
entire property is in that riparian buffer.
a large part of it.
Okay.
Did you get an LOI for the site, a letter of interpretation, which verifies where the freshwater wetlands are, what the transition area is? Well, you know, my concern is that you've had these conversations, and I'm not disagreeing that this might be the opinion, but I have no plan that shows me where the wetlands are. I have no letter of interpretation that shows me, yes, DEP confirms this is where they are, and that the transition area is 50, 150 feet. And you know, you're asking me to believe your testimony, and again, I believe your professional opinion, but it's hard to believe without the documentation to support it, that every other applicant is asked to go to the DEP and get these documentation, and you just want us to take your word for it without any backup support at all.
Well, the response to that is, what is your opinion of having, well, I think it's a very fair question. What is your opinion about having a natural buffer versus a fence?
I
Isn't that-
could form an opinion if I had a plan that showed me the alternatives, but I have no plan that shows me the alternatives. I don't know the location,
So
I
in
don't
other
know the
words- so in
location,
other
the
words-
number of trees, the species, any of these details.
So in other
You're
words,
asking this board to make a decision on whatever.
well, I've already given you my alternatives, and if it turns out that you want an alternative, you want a plan, Mr. Reagan can provide that plan.
I asked for a plan in my March 4th letter, so about a month ago, I asked for a site plan to show the fence location or the vegetative barrier, and also the trash enclosure location, which we haven't even spoken about tonight, but no.
Well,
plan
no,
is
we've
also
actually,
presented.
we've actually talked about the trash enclosure at least 4 times. I have. I don't know, maybe not you.
Not on a plan, you haven't shown us where you wanna put
The-
it, you're
the-
asking
the
for
problem-
relief from
the problem
condition without
is-
giving an alternative,
The
showing
problem
the
with, the
alternative.
problem with your suggestion is that up until about a week ago, there was no real evidence that we were going to end up being in a position to convince either the railroad or the county that we're going to be able to move forward with this application. But now we end up feeling as though that there's a good possibility. So therefore, the idea of spending more money to end up putting in another site plan, alternatives, etc., really, in my opinion, did not make sense. That doesn't mean it can't be done. And as I said to you about now 20 minutes ago, I'm willing to end up, and I'm sure my client's not happy with me, but I'm willing to end up saying, we want an approval, and I've already outlined what I think that approval can be, which is another series of waiting for outside agency review, or alternatively, you can end up carrying this matter to whatever time frame you think is appropriate, whether that's 1 month or 2 months, so that we can then prepare and satisfy your engineer with regard to the things that she had in her letter. That's not that hard to do, and we can end up maybe during that period of time get some answers from the railroad and from the county. The concern that I've got is that I've got a situation where I've been told, unless you guys end up doing something, I'm going to start fining you, and it's not an insignificant amount of money. And I understand you don't have the ability to control, but I think you have the ability to influence, and there's nothing wrong with using that word.
Yes, we understand.
The other question I have is you're talking about vegetative relief across the back, and I'm not against vegetative relief, although there are a lot of vehicles parked behind, and I'm worried about if vegetative relief gets damaged, he dies. And then you have a bunch of dead trees or dead bushes or whatever you're talking about in the back.
No offense, I've got an answer to that. I've represented boards now for longer than, well, no, I've had gray hair longer than I've been representing boards. But the fact of the matter is, my opinion, and I assume your attorney's opinion is the same as mine, and that is, if we have a condition that says we have a vegetative buffer that's part of an approval, and that vegetative buffer starts getting hit by trucks, by cars, by kids, by I don't care who, by an asteroid, that needs to then be replaced. It doesn't rely upon a 2-year landscaper's guarantee. If it dies, it needs to be replaced. And that's part of your approval process. And I'm sure that's going to be the interpretation that your attorney's going to give you. It's certainly been mine over the last 45 years.
Either that or we could put a guardrail there that would protect the vegetation, and that wouldn't be a fence that the DEP doesn't like. Guardrail. They don't like fencing because fencing stops water from flowing if you get a flooding. That's why they don't like it by flood zones.
They don't want.
Guardrails don't hold back water. I think we've had them in other locations where we had vegetative right behind it, and we had a guardrail right in front of it. And because it doesn't hold water, the DEP doesn't usually get too fritzy about it. It'll protect all you're gonna spend all this money for vegetative buffer, and then it's gonna get run over.
Can I, say something before?
That's my
Thank you.
issue.
I want to remind the board of what phase we are in this, and that we're not at original site plan. What I'm hearing is that a condition of approval could be this landscaping and subject to board and planner and professionals to look at, but we have a site that's operating, and you're seeking amendment, and it's been years, and, you know, I don't think I need to beat a dead horse, but we don't have plans. I think what we're referring to is we have truck movement. I'm not really sure what the width is back there, what the existing conditions are back there. I know there's already some vegetation back there, and apparently it's not doing its job because that's the whole point of the condition, is to stop the trash. To say that this could be a condition of approval, I mean, we are already at approval. This is an amendment to conditions.
I understand.
I think this board needs to understand, like I said earlier, I don't know, like, if this is a double row we need. I heard that this could be 5 or 6 feet arborvitae. I really need to see more, because what was originally the intent is, because this is a D1 use variance that was granted, use with parking.
Understood.
And it might not just be garbage. I might have to need to go back to, I might even have to listen to the minutes or the hearing from 2018 to really hear what was the deal with this fence, and is this landscaping actually addressing that?
Well, since I wasn't there in 2018, I defer to you. I'll let you listen to the tapes.
Have you requested the tapes?
No.
We have a resolution, but they're all recorded, these minutes.
I'm sure they are. The fact of the
I think
matter,
it'd be useful to get a copy of that, Colleen.
and feel free to review those. And we will be more than happy to submit to you a plan outlining what we think is a reasonable resolution of that issue based upon what we understand to be the case. If you tell us during the course of the next month or two, or whatever the board wants to carry this to, that you don't think that that's sufficient, then we'll be happy to have that dialogue with you. It's not that hard.
And then
This is
just,
not
I
that
have a
complex.
clarification question. So your application wants to remove condition D, which says the applicant engineer shall locate and designate on the site plan a single enclosure for trash and refuse to be located at the direction of the board engineer. Is that being removed from your application?
No, we've already said that we'd be more than happy to.
Well, that you're just gonna do the condition?
Say that again, I misunderstood what you said.
Your application asks for relief of that condition, but now you're saying you're going to meet that condition.
We're
So which
not-
one is it?
Yeah.
Are you asking for relief, or are you going to meet that condition?
The fact of the matter is that we will be, no, we're not asking for relief. We can end up asking for, if you want, end up guidance, or we can put it where we think is appropriate. And if you tell us that it's not in a good location, subject to reasonableness, of course, we're perfectly happy to work with your professionals in regard to the trash. Again, you know, it seems to me that this particular fence slash a natural barrier versus the other condition in terms of the trash enclosure, we don't necessarily want to have the tail wagging the dog. That's not the thing that's been holding up this whole process for the last 5 or 6 or 7 years. What's been holding up the process is the whole issue that we've been dealing with since I got here at 7 o'clock, and it is now 8:30.
Mr. Thomas, if I may. So, I would like to propose something, and this is just me talking without consulting. I think this Koch was going down the avenue of possibly allowing us a little more time to, what I think is going in the positive direction with at least the railroad. And she's correct that I still have to talk to the county, potentially the DOT members. I do agree with you board professionals that there needs to be a plan to understand all this. And they verbalize some things, and there are more things that are also important to me that needs to be shown. For instance, by moving that drive aisle there and having the circulation around the building, it changes some of the some of the site features that were proposed in the approved plan. For instance, there's some parking spots that were shown there that I can't maintain if this ultimately the circulation gets allowed by the road. That's why I started at the very beginning saying it was my opinion that I can't finalize a revised site plan, amended site plan to this board until I know the outcome of the railroad, because that has a huge bearing on all these other things. So it's more, I agree with you, and it's more than some of the correct items that you pointed out, but there's other items that once I know that the railroad is on board, then I've gotta take a look at the parking that was approved previously, because spaces are gonna change, things of that. So there are other things that I need to address as part of the site plan, but until I have the railroad's concurrence, as they say, with respect to what I think is the direction we're going now, I can't address all those things.
Okay, I think I know where we're at. And I would like the board to make a motion that we carry this until June 3rd. June 3rd will be the next meeting that we can hear this case, to give them time to organize. And then we send a letter to our zoning officer telling him that we're in hearing and we appreciate him taking pity.
And not imposing fines.
Not impose any.
That we're working on.
Put it in plain language, not to impose fines.
But
So-
when we come back in June,
So.
they have to have concrete approvals from the DEP and the railroad,
Okay.
and updated site plan, or please don't do this again.
Right.
My question was going to be, if we make a condition to postpone, can we impose conditions on that?
Yeah, well,
Where certain activities will need to take place? I think I got it.
Concrete
But certain activities would need to take place between now and that date. I'm thinking that perhaps we might go so far as to say we could address the trash enclosure. I understand the parking would be impacted by what right of way and all that jazz, so we probably can't address the handicap parking. But is there a reason why we couldn't address the trash enclosure plan at least this
Because they're
evening?
gonna have to put in a new site plan, it may not be applicable.
But could I comment on that, on the trash enclosure?
I was gonna say as per professionals, but go ahead.
Well, I just want to bring up that the trash enclosure really was, that the question was in this location. And it wasn't within the fenced area. There's two trash enclosures within the fenced area that the plan had said to stay. Even though it also says in the document that there's only one, so it conflicts each other.
Right.
We got rid of this one, so we just got rid of it, so it's not there anymore. So I don't know how that,
When you're
that was the
pointing-
whole question, was that thing wasn't
When
protected.
you're pointing out the plan, I was there today, because I wasn't very familiar with the site, and I was very happy that no one challenged me as I walked through your yard and took pictures. There's I'm gonna call it a 40-yard dumpster, I don't know how big it is, right up against the building, in that section that you just pointed to. There's also, it looks like a railroad car without a top on it, I have a picture, I don't know how much it holds. There's also in the fenced area, two trash containers that kind of look like what you have in a garden apartment complex. And again, I don't know the technical name of those. But, so there's more than, I didn't get so close as to look in them to see if they're, maybe one's for recycling and one's for.
No, those are storage bins, though, what you saw in metal containers, those are enclosed storage bins that also go to
Okay,
site.
the ones
They're
right
nothing
by
to
the
do with
fence.
garbage, yes.
They look like, okay, they
Yeah,
look
yeah.
like trash containers that you
No,
would
they're
see like.
seed
in
boxes that
garden
you use for
parks.
storage and bring
Okay.
to sites and stuff like that.
So the only trash container you have now is that big dumpster.
There's two.
Railroad car thing.
Yeah, there's one right up front by the gate,
Right,
and
that's
then
the one.
there's one by McCarter's.
Right, okay, those are.
And those are the two that it said to stay.
So,
I just wanted to say that on the trash enclosure, that we got rid of that one. Just
so
to read that.
I'm thinking that we really need to wait
Right,
until we actually
Okay,
can
and that's
see
where I was
how
going.
things will be placed, how things will be organized.
Could I
June 3rd is the next date, that should be enough time, hopefully. Hopefully, if they don't have, we'll be willing to carry it for another month.
Yeah, I'm looking to see if there's some, condition we can impose with it, along with the continuation, that the owner of the property could implement to show good faith. That's where I'm going.
We just need the conditions from the
So-
DEP and the, you know,
Okay, so,
get certification.
Just to receive copies of all their communications.
right,
Oh, yeah, you said that.
exactly.
Just
I
receive
mean,
copies.
and I know
of-
we've done that before,
To be
where we
supplied to
said
the
we wanna see
secretary.
their answers. So, I'm thinking, can I make a motion to continue? Is this
Yes.
appropriate? Okay.
Like,
You did.
we kind of have one, but we haven't really
Okay.
fleshed it out.
Well, okay,
It
so,
was made by
make a
you,
motion
seconded
to
by Bob.
continue.
Yeah.
They don't have to notify it, give notice again, Colleen, is that true?
Correct.
They
Correct.
don't have to give notice again?
No, they
Okay, okay, so with the conditions that during the extension, adjournment, whatever it's called, that the applicant, make an application to the DEP for the fence, and what was the name of that actual document, Samantha?
Their testimony is that they don't want to make the application, or they don't feel it's necessary. So I would ask that they have some sort of confirmed, you know,
Well,
We need
documentation that says
confirmation
that that's.
the county.
It's-
right, we need an application, I think, any further discussion, I think we need an application to the DEP for the fence.
I agree, because you know what, the amount of dumping that was done, it went right down into
The waterway.
And the waterway that was going into the purifier.
Okay, then I'm gonna
Chain link is going to keep garbage from going. If you're going to put up those trees, they have to be right next to each other to stop any
Right.
blowing debris.
Okay.
But Mark is right, you could put up
A guardrail.
a guardrail in front of the tree.
I would suggest a wooden split rail fence. That is
Okay, well,
something
then-
that the DEP commonly employs along
And
their limits of disturbance and things
Samantha's
like
right, we need to go back over there now on a site plan and see what the distance is.
that. Yep.
So Samantha, my
Well,
understanding is
fit.
that if
But that's
indeed,
stuff that has to be worked out, they have to come
Right.
back
Well,
on,
they have to do that.
yes.
my
And show us
understanding
how
from
it can work.
is that the DEP, if you make an application for a chain link fence and they say no, as you have pointed out, they say, you know, plant trees or 2 rows of trees or something else.
Split rail fence.
Can we,
Application.
can the
for split rail.
application say that, see, I'm not familiar with how the application process works. Can the application say, we would prefer a chain link fence for these reasons? However, now the reason the DEP might decline the chain link fence is why? Why would they not want it there?
I believe there was some testimony that we had spoken about, that it has to do with the proximity to the river and impeding floodwaters.
Okay, so it's
No,
about
it's not,
flood.
it's about 15 feet above that.
Well,
That's above.
I just wanna know what they're likely
It may
to
be in the
say.
buffer
Yeah,
choice.
it's in the riparian zone, which allows fences.
So is it possible to make an application for the fence and say, but if you really are, you know,
Split rail.
all down on the, you know, now you're ruling out the fence, is there some
Actually-
other physical barrier that we could put up beside?
We traveled quite
in
far
addition
from the
to
motion,
trees?
which was
Yeah,
a
I
motion to
don't know.
carry.
Yeah, motion to
A
carry.
motion.
My suggestion at this point is that they at least make a pre-application meeting request to the DEP. And I don't know if the applicant's listening at the moment. I think the applicant's listening, I don't know if his engineers. My recommendation would be, I understand that you've had communications. I would recommend that you do a pre-application meeting to the DEP, which is a very simple request. There's no fee associated with it. Essentially, you put together a map, a scope of work, you know, you could bring in the resolution and all these things, and that's a formal meeting with the DEP, where they will review it, and they will issue their recommendation. It kind of sounds like you've almost already done that over the years, but not in a formalized pre-application meeting settings. But what they say at a pre-application meeting is bound with notes that they send after the meeting. So if you got that documentation that they said, we understand where you're coming from, we understand why the board wants it, but, you know, per our guidelines, we cannot approve it because of X, Y, and Z, then at least this board has that documentation that they can rely on when you're asking them to remove that condition from your approved application.
Ms. Nell, in your experience, how long would that process take, what you just outlined?
If you put together the application, they'll have the meeting the next week.
Okay.
It's done via Zoom, it's done in person.
I think that request is reasonable.
Yeah, and it's
There you go.
done
That's the
with
answer.
the Morris County,
If you
it's done
said
with
that-
Stephen Dench
If
and
you
Chris
said that,
Watson.
now we're going to agree to it.
They're very responsive, yes. And if you have any issues, let me know, because I do correspond with them on a regular basis, so if they're not, you know, if they work with us because we're on the town side, if they're a little bit slower with you guys, let me know, I will try my best to expedite it. But they are very quick with pre-applications. Okay, quick.
So then I'll amend the reason.
And I think that's very reasonable for all parties.
That a DEP pre-application will be filed for the fence or some other barrier that will prevent dumping in the area. And then, we'll, based on the outcome of that, we'll proceed with the handicap parking and the trash enclosure based on the advice of professionals. And in the meantime, we'll reach out to the zoning officer to tell them to back off until we get all these issues resolved.
To ask them to back off.
That's correct.
That's fine.
That's good.
This is not a resolution, we're just going to
No.
propose, this is a
We're
proposal.
talking about what's going on during the intermission.
Exactly.
It-
Okay.
It's not a resolution, but it's an action of the board.
Okay.
So all,
I think the applicant will find himself in the same spot if they don't, even if it's not conditions. He'll be in the same spot as tonight.
Yeah, so-
We understand that we understand what you're looking for. I've already talked, Mr. Reagan has already indicated that your engineer made a very reasonable suggestion. We will follow up on that. We will report back to you either in advance of the meeting of the 3rd, or if we don't get any response, and she doesn't have the influence that she thinks she has, I hope I'm wrong, but if it turns out that we get crickets, we will report that back to you on the 3rd as well.
okay, thank you. And you'll also supply communication.
We'll supply any communications that are taking place with any outside agency to your wonderful secretary, who has been very helpful to me.
Thank you very much. And everyone on the board is in favor of this, say aye.
Aye.
No, anybody opposed? No one is opposing, so.
Just so you know, you're second.
Just a footnote to the
You're not first.
folks from the public, you will not be
You're not
receiving
first?
another written notice. So you have to mark your calendar for June 3rd at 7 o'clock to be here, okay?
And hopefully you understand what's going on. We hit technical difficulties, and there's so much stuff going on there that we have to get some more detailed information about what's happening before we can even make a decision. That was the motion we just had. The motion to carry,
If that, oops, I'm sorry.
and we will notify the zoning officer what's going on, and everything will be good.
Ladies and gentlemen, thank you for your attention. I wish I could say this was I think in some ways it's a simple application. Unfortunately, we have outside agencies that make it more complicated than it really should be. But thank you again. We'll see you on the 3rd.
Thank you very much. Thank you, everyone. Thank you. Now, is there any other business that needs to come before the board? Seeing none, meeting is adjourned. Thank you all for coming.
Someone safe, everyone.